They say creation, Cabinet says creating for absorption, not for fresh recruitment. If all these similarly posted candidates like Shoma Das are to be recommended, 5,261 posts are required to be created.
Just the off the track. Now, if the commission has all the records to identify 1932 assistant teachers for 11, 12, 247, 19, 247 for 11, all the numbers, including Group C, Group D, suggesting the cabinet to cancel their at a go. What is the difficulty in identifying them?
This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Mr. Dasgupta, do one thing. Prepare an index.
I have already prepared, my lord, since all the judgments are...
Yes, prepare index with reference and the proposition on which paragraph.
But this judgment also deals with what is scope of absorption and absorbed employee.
Paragraph 8.
Paragraph 8, 733 judges bench. I would rather place from paragraph 7. The second contention is that definition of expressions absorbed post and absorbed employee in section 2 of the Act are wide enough to take in the sweep not only a person holding an absorbed post before December 20, 1961, but also one who has been merely serving in a higher post, and that accordingly such higher post is also rendered in relation to that person an absorbed post. We are afraid this construction is clearly unsupportable. The definition of this expression in section 2A and 2B of the Act read, absorbed employee means a person who immediately before the 20th day of December was holding an absorbed post, who on and after the date either served or has been serving in that day or any other post in connection with the administration of the Union Territory of Goa. Absorbed post means a civil service or post which existed under the former administration and immediately before 20th day of December 61. These provisions in the interpretation clause merely indicate that an absorbed employee should have held the absorbed post immediately before so and so, and that it did not detract from that position if subsequently he was serving in any other post in connection with the administration of the Union Territory of Goa. It is erroneous to construe that in such circumstances the other post would also become an absorbed post. In relation to such person, he would continue to be an absorbed employee. Therefore, absorbed means someone who is working is taken into job, nothing else. Now, another important judgment on supernumerary, which was cited by Mr. Bandyopadhyay at the preliminary stage, will have immense application and impact on the whole issue. This is 1978 Supreme Court cases online, Delhi, page 82, Division Bench Judgment of Delhi High Court. আমার মার্কিংটা কোথায় গেল? Yes. Now I shall take your lordship to the paragraph 6 and onwards. The background for the administrative action is provided by two central acts, which work in harmony with each other, namely the University Grants Commission Act and the Delhi University Act. Under Section 12D of the UGC Act, the UGC, for the purpose of performing its function under the Act, may recommend to any university the measures necessary for the improvement of the university education and advise the university upon action to be taken for the purpose of implementing such recommendation. The above mentioned scheme was proposed by the UGC to the universities in India, a recommendation to improve the university education because the provision of supernumerary post, kindly underline this, because the provisions of supernumerary posts to academics returning from outside posts of national importance to their respective universities was a part of the overall improvement of the university education. Similarly, the UGC advised the universities upon action to be taken by them, namely, to make detailed proposals to the UGC regarding what supernumerary posts they would like to create and for the benefit of which the deputationists. Further, the UGC also advised the universities upon action to be taken for the purpose of implementing the recommendation, namely so and so. Therefore, the scheme for supernumerary post is for the purpose of the absorption of the persons who are working. And then next paragraph. The UGC scheme could not be implemented by the UGC itself without the cooperation of the universities. For while the UGC could finance the supernumerary post and attach conditions as to who were to be appointed to this post, etc., the post had to be distributed among the different universities. They would be supernumerary posts of the universities provided by the UGC. The action to implement the scheme creation of supernumerary post with the aid given by the subject to the conditions attached to the post by the UGC had to be taken by the academic council and the executive council in their respective spheres. Under the Act, the academic council is the academic body. The executive council in the executive body university under section so and so, but I am not troubling a with that. Then kindly come to me, Lord, the relevant portion. Paragraph 11. A normal appointment of a university teacher has to be made on the recommendation of a selection committee. This is reinforced by Statute 18A. If, however, the condition of the UGC scheme is that its benefit is available only to persons who had previously held posts in the university, then the implication was that these persons had been recommended by the selection committee before they were originally appointed university teachers, and the requirement of section 6.2 and 18A was satisfied in respect of them at the time of their initial appointments. Thereafter, they went on deputation. After their return from deputation, the question of selection committee did not arise. They were not being appointed as university teachers for the first time. Their comeback was not a fresh appointment, and no recommendation of selection committee was necessary for their comeback. This is respect of respondents 4 who had already been professor at the Delhi University before they went on deputation and who were entitled to return to their post as of right at the end of their deputation. This did not, however, mind, occupying the post of supernumerary professors so that the incumbents of their old post need not be destroyed by their turn. Universities made arrangement that you want better people. He was working in Delhi University, Calcutta University wants to bring him. Then for him, a supernumerary post is created. Therefore, supernumerary post, the grammatical meaning also, leads that supernumerary means a number, you are doing something exceeding the number. This concept was developed in a cadre studies. Lordship is well aware, for the IAS, there is a cadre strength. For the IPS, there is a cadre strength. Equally, my lord, in all services, there is a cadre strength. While we are discharging functions, some situations may arise where somebody was found to be working, but may not have any place in the cadre strength. So what do you do? You throw the man out who was appointed otherwise. Then you create a post which is called supernumerary post so that this man can be absorbed.
Beyond the number.
Beyond the number. Therefore, supernumerary itself is something that you are going beyond the number.
And possibly that is why with the retirement or with this, that post abolition.
This is personal. The man goes, post goes. The cadre strength remains unaltered.
Remains same.
Now, my lord, These are all relating to the absorption and creation of supernumerary post.
2007, 2007, 8 SCC 160.
So what is your job? The other thing, the vacancies were calculated according to the post sanction, how it works out. Rule 8. Sanction stands for the schools are there. Beyond sanction stand, no teacher can be appointed. So there may be vacancy occurred while advertisement was there. Supposing 1,000 vacancies are there in all government aided, whatever the schools, then advertisement was made. This 1,000 is within the or the sanction strength. Now, before the selection, the final list is according to the why this leverage was given. That maybe during the process, a new vacancy due to retirement or other situations occurred, that will also be included. But it is within the sanction strength. Now, this plus post supernumerary will offend the sanction strength of the school, where it could be accommodated.
But first of all, this is not a cadre service.
Now, where they will be accommodated? Supposing this 7,000 or 5,000 teachers are given, then the corresponding...
They will completely without loiter around. Because the rule says you have to first identify the vacancies existing or anticipating. And that's why they say that when you publish...
Much match with the sanction strength?
Not.
Sanction strength, vacancy is...
Declared vacancy.
Yes, must match with the sanction strength.
That's true.
So, if today 5,000 new supernumerary post is created, how this sanction strength will be matched?
It will never match.
Where they will go then?
Loiter around. Loiter around.
X school has requirement of one work education teacher, one physical education.
Doesn't matter because this is out of political expediency. The resolution is this. This is not out of academic expediency. Whenever, first of all, again, if your lordship go to the rules, but the vacancies, the categorizations are there. Before you declare, all these categorizations are taken into a bucket. Then it declare it. Even the rule says that it may so happen that before the final selection, 15 days before the publication, also vacancies, which should also be declared that these vacancies come. So that final vacancy position is terminated on that date. Thereafter, any vacancy, that would go for the next year's selection.
No, these 5,000 odd vacancies were, when it was declared to be filled up, but treating it as a supernumerary, was the sanction strength of the corresponding schools were taken into account?
Kindly come to the rules once again.
No, it was taken into account. Yes. Cabinet decision that there was a...
Cabinet decision did not at all consider that.
That is what? The cabinet decision, cabinet
decision doesn't say that. What is troubling my lord's query, the cabinet decision doesn't say that. Cabinet decision says the selection is over, the waiting list people are there, they are demanding employment. Therefore, to tackle the situation, we create this.
Supposing supernumerary post can be created, supposing, but you have to fit in these persons against some post which are sanctioned post.
Now this is new creation of post.
Where they will go?
That is, but I could only say, my lord, they will simply loiter around. Where is the assessment?
How the salary would be paid? Because the
special sanction? Cabinet had to specially sanction fund for this. Can't read the cabinet decision. Shocking in every respect. They say for this purpose, finance department says, I referred it to your lordship. This is a proposal of School Education Department, a part of the cabinet decision with the paragraph 5, views of Finance Department. The Finance Audit Department, Government of West Bengal, has agreed to the proposal of the School Education Department, Vide so and so, with the following observations. This is a proposal of School Education Department for creation and filling up of 5,261 supernumerary posts of teaching and non-teaching staff, and creation and filling of another 1,600 supernumerary posts for work education, physical education, involving a sum of
Not
rupees.
for creation. A school education department proposal was absorption.
No, the cabinet says absorption. Balaji is rightly striking. They say creation, cabinet says creating for absorption, not for fresh recruitment.
Is there any difficulty for finance to sanction the financial or the accord the financial sanction if it is absorption or there?
No, only say if these posts are created which are beyond the budgetary understanding,
Mhm.
then we have to bear the additional cost of 262 crores. Now,
Lack of harmony.
that if your lordship go detail into it, Milord, more shocking things would reveal. Now, Milord, my learned judge insists me to cite another judgment. I just place it. Though to me, Milord, these points have been already cited. This is 2007, Volume 8, Supreme Court Cases, page 161.
Paragraph 911.
What about the 4.6? Paragraph 9. Judgment of Justice S.B. Sinha, I believe. Yes. Recruitment for teachers in the state of Rajasthan is admittedly governed by the statutory rules. All recruitments, therefore, are required to be made in terms thereof. Although Rule 9.3 of the rules does not specifically provide for the period for which the merit list shall remain valid, but the intent of the legislature is absolutely clear, as vacancies have to be determined only once in a year. Here, the rules prescribe that. Vacancies which arose in the subsequent years could be filled up from the select list prepared in the previous year and not in another manner. Even otherwise, in absence of any rule, ordinary period of validity of select list should be 1 year. In state of Bihar, so and so. Then paragraph 11, it is well settled principle of law that even selected candidates do not have legal right. Paragraph 12 is quotation from another judgment. I just will not read it. It is settled legal position that merely because a candidate is selected and kept in the waiting list, he does not acquire any absolute right to appointment. It is open to the government to make the appointment or not. Even if there is any vacancy, it is not incumbent upon the government to fill up the same, but the appointing authority must give reasonable explanation as with regard to if they do not want to fill it up, why is they given it? Nothing else. Therefore, the principle is that
here in the case, it is an admitted position, panel has expired. That has been appointment beyond the time has sought to be justified, that since there was a delay in completing the selection, it has automatically extended.
Automatically. No, since the matter was pending before the court. It's a fantastic logic. Anyway, now another point which I am just concluding. Lordship has seen without the section 19. এটা হচ্ছে আমাদের ডিভিশন বেঞ্চ জাজমেন্ট
This is division bench.
Well, no, not this division bench.
No.
Because this bench was presided by Justice Talukdar.
Oh.
Because when
What was the issue before the
Park Commission's report and other things were considered, he had questioned Councillor about the authority of the state to issue directions under Section 19 beyond the provisions of the Act. But kindly come to 4.6.4. That কিচ্ছু দরকার নেই আরে আমি ডাক দিলাম এটা বলি অন্য কোনো দরকার নেই We have already observed that 4.6.4 that Mr. Taposh Paja, Senior Law Officer of the School Education Department, has stated before the inquiry committee that his opinion was not obtained at the time of constitution of the Supervisory Committee of November 1, 2019, though Mr. Manish Jain has tried to justify the constitution of a supervisory committee under Section 19 of the School Service Commission. Mr. Manish Jain was the secretary. Under Section 19 of the School Service Commission Act, as advised by Law Branch of the School Education Department. In view of the contradictory statement between Manish Jain and Taposh Paja, and in absence of availability of any written opinion, Mr. Paja, we are of the view that the opinion of Mr. Paja was not obtained at the time of constitution of the Supervisory Committee. On consideration of the provisions of Section 19 of the Act, we find that state government can give direction from time to time to the Central Commission in conformity with the provisions of the Act, by which Commission will be guided in discharge of its function. In our considered view, the constitution of a committee by order dated so to supervise, monitor, and guide the functions of the Central Commission in connection with the pending recruitment process by the persons who are not part of the Central Commission, and by making Dr. Shanti Prasad Sinha as convener of the state committee, who is neither part of the School Education Department nor holding any sanctioned post of the Central Commission, cannot be construed as direction of the state government in conformity with the provisions of the School Service Commission Act 1997. Therefore, even the constitution of a committee by the minister, all of them are now in custody, was found by this division bench beyond the provisions of Section 19 of the Act.
So this question possibly I also asked in some other matter, where it came to the notice of this court while taking in the other determination that at one point of time the commission was directed not to deal with any matter. School Education Department took over all charges. Then whether the question was whether a statutory commission which was been created
could be defunct
by this. Now here Section 19 is subject to this. Now this is an independent statutory body. It may at least point out to the state that here there are places where your direction offends the rules which is operating in the field of appointment. Is it not the obligation of that statutory body to point out?
Was it? That's their main duty. They are created for that. But as I say, because you have been empowered, the question is whether it will use it as a sword or as a shield depends on your own.
As you are right from the beginning, you are highlighting even the executive instruction under Article 162, possibly, whatever, that this is subject to the other provisions of the Constitution. So the mechanism is such that to look into adherence to Article 14, these bodies are there. So
they are created, they are the trustees of the people's right.
Exactly. If they fail to discharge that, it is nothing on record to suggest, at least to return to the request of the government that these are the areas where commission cannot do that, or is supposed to not to act in that manner because of these restrictions of the rules, but this has not been done.
On the contrary, they have recommended. The memo, cabinet memo says school service commission has recommended.
Recommendation comes after this decision of the cabinet.
Kindly come to it.
Page 3, 4, internal page 3, 4. Page 3.
We kindly come to the internal page 2. There, Lord, you'll find the chairman of the Central School Service Commission.
মুলতানি না করে উপরে লেখো, বিকাশবাবু দেখো।
Page 2 of the internal page 2. Sorry, 3.
Supplementary affidavit, page 5.
লিখে দাও, ওটা দাও। এক মিনিট দাও ওখানে, আমার কাছে আছে। একটু এদিকে কানটা খাড়া রাখো, গল্প করো না বসে। আচ্ছা ধরুন এই বান্ডেলটা একটু নামান, এরপরে internal page 3.
Yes, the proposal of Central School Service Commission and Commissioner of School Education under the heading. Got it? The Central School Service Commission, Chairman West Bengal Central School Service Commission, with a letter dated so and so, placed a report to the state government stating that 5,261 numbers of candidates have been affected by rank jumping in the first SLST and third SLST, and 1932 posts of assistant teachers for class 9-10, 247 for assistant teacher 11-12, 1102 posts for group C, and 1980 posts for group D. And if all these similarly posted candidates like Shoma Dash are to be recommended, 5,261 posts are required to be created.
So this is a suggestion of the commission.
Yes. Then the chairman School Service Commission further, days later dated so and so, placed a report to the state government stating that there are 751 numbers of candidates for 11-12 group C, group D who are not in any list, either in panel or in wait list. The West Bengal Secondary Education has also confirmed the fact of such appointments of non-teaching staff beyond the list prepared by the commission. The chairman of the commission further stated that for teaching posts 9, 10, 11, 12, who do not feature in any list, either in panel or wait list, should be cancelled by the commission without waiting for and direction of the Honorable Court. This was honest suggestion. Similarly, for cases relating to non-teaching candidates group C, group D who do not feature in any list, may cancel the appointment letter directly. Proposal of the Commission for School Education is, the Commissioner of School Education with this proposal dated so and so proposed to create such number of posts.
So this is a proposal.
Observe. The School Service Commission says that they should be terminated.
Whatever those names are.
Now, the Commissioner of Education, that is the official secretary of the Education Department, he says that 16 numbers supernumerary posts, breakup 750 work education, 550 physical education, to absorb all waitlisted candidates of physical work education subject to validation of panel.
Just the off the track. Now, if the commission has all the records to identify 1932 assistant teachers for 11, 12, 247, 910, 247 for 11, all the numbers, including Group C, Group D, suggesting the cabinet to cancel their at a go. What is the difficulty in identifying them?
You go on searching difficulties, we cannot have an answer. And that too for a particular category whose names were not in the list. They were appointed. The other things are there.
So, to this, can we take a look of the commission's affidavit here?
Yes, kindly see the commission's affidavit. SSC has also made a supplementary affidavit. মেনটা দাও,
দুটোই দাও, সব দাও আমাকে, ওটা খুলে ধরে দাও, ফাইলটা ধরে দাও, পাঁচ করে ধরে দাও। One is of supplementary.
Siddhartha Majumdar has affirmed this affidavit. November দেখছি তো।
One was given affidavit in opposition on 28th November 2022.
28th November, yes.
Other supplementary was affirmed
on 19th February 2024.
24.
Number, they have wasted 3 pages on the ground of maintainability. We'll start from paragraph 7. Paragraph 6, all maintainability by statutory body. Now paragraph 7, their statement comes.
Opposition or supplementary?
Opposition.
Paragraph 7.
28th November.
Paragraph 4. 7, yes.
It's important to read. I'm reading that. I deny that the petitioners are entitled to be called for verification or that there are several discrepancies or illegalities in the merit list. My lord is not dealing with that. I'm not troubling my lord.
No.
Then kindly come to me, lord, paragraph 9. With regard to government order dated 19th September 2022, got it? Whereby the government proposed to create supernumerary posts for assistant teachers. I say that the government order came as a policy of the government for accommodating waitlisted candidates. The commission, merely being the recommending authority, has no role to play other than implementing the directions of the school education department.
Correct. It is not correct.
Absolutely, we're betraying the trust.
This commandant decision suggests that this was actually initiated from the end of the
School Service Commission suggested. Government investment for which it issued notice it as so which is merely a schedule for conducting the counseling of assistant teachers for work education. I deny that notification referred to an incomplete violation of Rule 12.4 of the rules. I say that the Rule 12.4 deals with upper primary teachers except physical work education. The petitioners belonging to are not governed by 12.4 but governed by 13.9, all the same. Then, with regard to the petitioners being called for verification after the creation of supernumerary post, I say that the question did not arise as the supernumerary posts were created for the leftover waitlisted candidates who are actually successful candidates, who could not be recommended for want of vacancies. But if they could not be recommended want of vacancies. How could it be successful? Then everybody is successful. Because if they've got vacancies are marked, if anyone who doesn't come within the purview of the vacancy is unsuccessful.
What is about the expiry of panel? Is there any suggestion and any statement regarding expiry of panel here?
Well, I do not find, Milord, about their statement that, yes, kindly come to Milord. No, nothing is there. State Board is my automatic extension, but the SSC in the first affidavit doesn't say anything on that, but in the see the supplementary affidavit. Oh, I mean, the supplementary affidavit, they have annexed the application by which they wanted to say that these posts are created to accommodate illegal appointees. Therefore, the SSC, in fact, which your lordship, I think, is trying to search out, has betrayed the confidence vested on them by the statute.
If a statutory body does not work for which it has been created, removal of the
Yes, but the state is empowered to dissolve it. State didn't want to dissolve them. State didn't want to not use them for these illegal purposes.
the of the post holders, rather the office bearers should be removed, or the entire commission?
Entire board will be dissolved. The law say permits them. Barker provision था. আমি যা বলছি সেটা দাও। ও ফার্স্ট প্যারাগ্রাফে ফার্স্ট অ্যাফিডেভিটে ও বলে just a minute দেখি oh yes no on the expiry they admit it. I am thankful to my junior. Page 3 of the first affidavit, subparagraph D.
Yes, I have also marked it.
That they can dissolve the body.
Yes,
Section 20 of the Act. কি বুঝবে বলো তো এই যে তো মাথায় ঢুকলোই না
পেজ নাম্বারটা
পরে বলে পিছনে Section 20, dissolution of the commission if the state government is of the opinion that the commission has failed to discharge its functions under this act. In accordance with the provisions of this act, the state government may, by an order published in the official gazette and stating the reasons thereof, dissolve the commission with effect from such date as may be specified in the order. Upon the dissolution of the commission under so and so, all the members of the commission shall be deemed to have vacated their office.
See, selection test is over.
It was over yesterday.
It is over.
Examination.
This 14th one examination was there.
Okay.
The written exam for 9, 10, 11, 12, that is complete.
Exhibition में जाना था.
What else then?
The selection process is like that, so many things.
Manipulation, everything debates.
No, at this stage that cannot be switched over to any other body.
No, that you do not do it.
That will create another chaos. No?
The judges of these courts are maligned every day. And I don't want to see that the other. You have already sufficiently maligned.
No, only I was inquiring. There is a power for the state government to dissolve.
Yes. Okay. Para 352.
Therefore, the whole scheme of the Act is a complete one.
It's a complete, Lord, watertight code, if I may use that expression. If you follow the statute, then there is a scope for any slipping of corruption. No. And you have to be transparent. Everything has to be transparent.
Should we continue in the second half or tomorrow?
No, I'm taking a নিচে মামলা আছে তো?
হ্যাঁ direct। আর এখানে জিটিএ
Oh, I'm second half is GTA matter.
Second half is in the GTA.
But tomorrow, I will take another 15-20 minutes.
And ask Mr. Advocate General to start tomorrow.
আজকে রাখছি না,
আজকে
First
না।
off,
কালকে সে সকাল
28 মিনিট show.
এই GTA টা আমাকে নর্থ বেঙ্গলে দিয়েছিল
But tomorrow at 2?
2 or 10:30. Because if you complete, then I ask with the Advocate General to start.
Then not Lordship, if Lordship give me this indulgence, may it start at
2 p.m.
no 2 p.m. or 11:30?
Very well, 11. Some motions are there after.
Right.
After some motions.
So that I
Convey
can
it to Mr. Advocate General.
earn something here and there.